Okay. So when we stream here, Facebook has a slight delay getting on. So I'm gonna give everybody a couple of seconds. Thank you to everyone who is tuned in. We will get started in a moment. Can everyone see my screen?
Yes.
Yeah. Okay, just making sure. All right, Natalie, you're unmuted again. Okay, you can just unmute yourself when you get ready to talk now. Okay, so I can see we have some people on. So hello, everyone. We're going to get started in one moment. We're just giving everyone a couple of minutes to get on. And we'll dive right in. We are streaming live on Facebook as well as YouTube. And thank you all for joining. If you have any questions, be sure to type them into the comments. We can feature your questions and bring them onto the screen. If you know anyone who needs this information, please share on your pages. All right, so we're going to go ahead and get started. Okay. Are you all right. Welcome everyone to our collective conversation, which is entitled Child Custody, Visitation, and Quarantine. So today we're going to be talking about the complications and the things that are coming with the territory of us all being on quarantine, specifically those of us who are in divided and blended families. For those of you who do not know me, my name is Marissa Grayson. I am the founder and managing attorney of the Collective Legal and Crisis Management Firm. We are primarily based in Los Angeles. We have attorneys on our team in other states. And today we have 3 attorneys on the line who will be chiming in on the child custody subject for the day. The purpose of our collective conversations, we've been hosting them for the last couple of weeks. It's just for us to be a resource to everyone and to share information that we know is not necessarily readily available, and just to give everyone some insights so that they can navigate this unknown area, and then just a lot of the issues that will be coming up in the future after quarantine is over. Of course, we'll continue to do collective conversations on various topics that affect many people. So if you have any topics that you would like us to cover, feel free to shoot us an email or put it in the comments section. So again, thank you all for tuning in. I'm Marissa Grayson. I'm the founder and managing attorney of the Collective Legal and Crisis Management Firm, where we handle all types of cases. Today, we will be talking about child custody, visitation, and quarantine. So I would like to introduce the 2 attorneys that I have featured today. Today, we will be with Deborah Pino, who is a child custody and family law attorney located in South Florida. And we also have Jolena Pickett Lewis, who is also a family law attorney, and she is located in New York. So we'll be going over just some things that you should know and consider when it comes to co-parenting and child custody and visitation during this quarantine. Our disclaimer that we'll go ahead and put out there. Of course, you guys know this is not legal advice and should not be construed as such. This video is for informational purposes only. So if you have any questions, we're happy to answer, but just know that we are answering in an informational capacity only. If you need legal representation or specific legal advice that is suited to your circumstance, we definitely advise you to contact the lawyer. You can contact one of us. We will have all of our information available. So let's go ahead and jump right in. Okay. So thank you again for tuning in. So ladies, let me get you guys on the screen here. All right, y'all bear with me. We got a new platform we're using, okay?
Right.
All right. Just for you guys who don't know, the collective conversations are pretty informal. We are lawyers, we are professionals. Our team consists of, so many different professionals that are not necessarily attorneys. So the way that we service our clients, we service them on a full scope, holistic type approach. So we handle everything from their mental health needs to their crisis management needs, their communication strategy, and so much more. We have a parenting coach on our team, a domestic violence recovery specialist, as well as a bunch of other, specialists and experts. So these conversations are not buttoned up. We are very, informal. It's meant to be like a conversation just amongst friends that all of you who are watching on YouTube or Facebook just so happen to sit in on. So we're just going to have a conversation, grab you a snack, grab you a drink, bring your questions, and let's dive right in. So ladies, the first thing I want to talk about is just what are the courts looking like where you are right now? I know in Los Angeles, our courts are essentially shut down for the moment. Yeah, we can still submit documents for filing. And if there are true emergency situations, then of course we can, file emergency motions, which, we can go into court for. But I know that a lot of courts are closed and not accepting any hearings. So what are your courts looking like right now?
So go ahead, love.
Go ahead, Deborah. Okay, so in New York, we're essentially closed. They just this week they started accepting like video conferences for certain pending matters that judges think are close to being resolved. So it's up to the judge to decide if they want to set up a video conference. But other than that, it's still pretty much like emergency hearings. We can't file anything at all. So we can't file any new cases. We can't file anything that's not essential. So we're pretty much on pause for now, but hopefully within the next couple of weeks, we'll start opening up a little bit more and we'll be able to file things and get things moving.
Well, honey, we fire hot down here. The courthouse is closed to the general public, but we can still electronically file. The judges are still conducting hearings. They're holding trials. They're taking evidence electronically. We are moving right along. COVID has not stopped us one bit. It has delayed us a little, and it's put us in a position where we have to do our hearings by Zoom. Some things have been pushed back if both parties and counsel and witnesses and court reporters are not all able to access the software, use the software. Everybody's not tech savvy, and some people are struggling, so they're at a disadvantage if they're required. But we're so busy here that our chief judge has entered an administrative order that talks about parenting and domestic relations cases, because we still fight and they still can't get it together. They still can't agree on everything. You more COVID than I am. You sicker than I am. You're not putting your mask on right. All types of things. So what I did was, because we needed some direction, so our chief judge was gracious enough to give us this administrative order. And what I did was I created a little slide that might help explain how bad it is down here. So I'm going to see if I can share this screen, because you guys changed formats on me at the last minute, so I'm not sure how good I'll be at this. But I'm going to try.
I don't think you're going to be able to share your screen. So one thing that we do want you guys to know is that all of our collective conversations will be housed on our website. We have a collective vault where all of the replays will be located. In addition to the replays, any references, any resources, any links that we talk about during this conversation, we have someone who's taking notes, and we'll be sure to make sure that all of that information is also located into our collective vault. So for those of you who are watching this, if you're watching the replay or if you're watching live and you want to be able to access whatever resources we're referencing, we will be sharing that in the vault. I have put the link on the screen so that you know is bit.ly/the collective vault. So that's where we'll be sharing all of that information. So Deborah, you can just send that to me and we'll make sure that we get that over.
Okay.
Okay,
so you don't want me to try to share it now, right?
I don't think you can because of is there a share button on your screen?
I see a share screen at the bottom.
Oh. Okay, go ahead and try it.
I'm scared to press it, but I'll go ahead and try. Hold on. Because with my luck, I'll press it and then I'll be disconnected. So give me a second. I mean, it's very informative and it goes through every possible scenario. There's one or two issues that still needed clarification that we were able to get some clarification on, but for the most part, it talked about who gets to keep the kids during the quarantine. Do you have to send your child to the other parent's house? Can the other parent refuse to exchange? And so I think I got it. Where are you? Okay, it says sharing screen. Share. And if it doesn't share in 2 seconds, then I'll just tell you what it says. So it says it should be sharing. Can you see a PowerPoint slideshow?
Nope.
Okay, so then I won't waste any more time. But what it does is it goes through step by step. For example, a call that I get often lately is who gets to keep the children if there's a quarantine or since we're in quarantine. And so the judge has decided that in the event of a safer at home or a shelter in place or a stay at home order, if that's issued, and it's pretty much been issued in almost every state, if your movements are restricted, you are then to discuss, which we know is an epic fail in most of our cases, but the parties are directed to discuss their family's best methods to meet the requirements of the child's school, even though we're distance learning, to have all the children remain together, the blended families, along with the families that are in the household, and to make sure that everyone is safe. So if you have regular time sharing and exchanges are supposed to occur to be consistent with your parenting plan and the government orders, regular time sharing is supposed to continue as ordered by the court without exception, period. If there's an order issued that doesn't allow you to move about the community freely, the parent who has 183 overnights is supposed to keep the children until the government's order is lifted, or if there's another court order. So in our state, and I'm in South Florida, if we have a parenting plan and the parenting plan says you get 157 overnights, but there's some order that's entered that prevents you from doing anything and moving around freely, then the parent who has at least 183 overnights is required to keep the children. If that happens, the court is allowing the other parent to have makeup time sharing. So once everything resumes to normal, then the parent who had less than 183 overnights is supposed to be able to calculate those overnights and somehow have that time returned to him over the course of the child's minority. So that's one of the things that was in our administrative order. The other thing was, the other question that I'm getting is, do I have to send my child to the other parent's house during the quarantine? Like, the order says time sharing should resume, but somehow in some people's minds, they still are confused about whether they have to send the child. And the short answer, according to our chief judge, is yes. Continued adherence to all orders by all parties is expected, according to his order. And unless you're in violation of an existing order, in some other case, like maybe you have a domestic violence case or you have a dependency case, each parent is prohibited, and I'm reading this word for word, from unreasonably restricting access to the child to the other parent. So unless you have a restraining order or unless your child is in dependency court and there's an order there that talks about time sharing, you are not allowed to prohibit your child from having access to the other parent, physical access. We're encouraging you to use FaceTime and Skype extra above and beyond what's in your order. But at a baseline minimum, you're supposed to allow your child to continue to have time sharing. But you have to have a parenting plan in place already. So you can't just say, hey, this is my child. There's been no court order that establishes paternity or establishes my parental rights, but it's my child, so I'm supposed to have time sharing. That's not what this court order is about. This directive is saying, as set out in your parenting plan, you're supposed to continue that exact schedule until the last day of school. And we find a way, we find loopholes, we always look for it, and we say, well, there is no school, but there is school. They're doing it from home. They're digital learning and distance learning and whatever they're calling it in your county, but that still counts as school. So you have to continue in that same parenting plan, as if the child was getting up and going to school. The next thing they want to argue about is, okay, well, we're supposed to pick up and drop off at school, and there is no school. The school is closed. So Judge Tudor had to go in and further define that as well. And he says, if the exchange is to take place at the child's school or daycare and the school campus is closed to the public, then the parents must arrange an alternate location. Again, this is like discuss and agree. We can't discuss and agree, and most co-parents aren't able to arrange. So he had to go in and further explain that the arrangement must be made in email, text, or parenting app so that it can be obviously verified. But in the event that you can't agree to an alternate location, the exchange is to take place at the police station or a sheriff's office closest to the school or the daycare. And as we know, there's going to be an argument about where the closest police station or where closest sheriff's office is. So we further went on to explain that the closest police or sheriff's office is to be determined by Google Maps, Apple Maps, or some other mapping program or website. And since we can find something to argue about all the time, if you can't agree on the mapping program to use and you're forced to file a motion, the court is going to likely rule on your motion without a hearing, which pretty much means if you file a motion saying, I want to use Google Maps, she wants to use Apple Maps, we can't agree on which one is the closest, and you file that motion, the judge is going to rule on that motion. He's going to use Google Maps or Apple Maps. You won't have any clue which one to use. And he's just going to send you an order that says, this is where the mapping program you're supposed to use, and this is where you're going to exchange. I found that this is the closest police station, this is the closest sheriff station, and that's where you're going to meet. So they're not playing any games in South Florida. We're still working, and we've laid it all out for you. This order that I'm reading from is on our website so that you can go and read it for yourself if you get confused and you're not sure. It's laid out in plain English so that you can understand that co-parenting issues are continuing and the judges are overwhelmed, and you're not going to be able to get the responses that you're looking for from most of these courts because everyone is doing this and it's difficult. But we're asking parents to be professional, right? We're asking you to, use some common sense, put the situation and the mistrust and the bad energy, I guess, aside for the moment, for the sake of the children, and let's try to push through this. The children need to be with both parents. They need to understand that both parents love them. You have to start to trust. I know this is probably a bad time to start trusting, but we need you to start trusting. So I don't know if that's happening in LA. I don't know if that's happening in New York, but that's what's going on in South Florida right now.
That's good information, because what's crazy is, Jolena, do you guys have any orders like that in place in New York at all? Because here
we don't have any clear directives like that. Our chief matrimonial judge put a letter in the law journal kind of giving his thoughts on the situation, but it's nothing official. So he basically said that people need to adhere to the orders that are in place. When the courts open back up, you don't want to be the parent that's keeping the child away from the other parent, or you can have some serious problems. Basically, that's the directive that we got from our chief judge. So we don't have the details like they're giving out in Florida. That's really helpful. That would be extremely helpful for us.
Mm-hmm.
Right. So, so that's good because Deborah, out there, you guys don't, I mean, it's pretty clear, right? And that makes sense that there was something that was issued that's that clear, because here we're kind of winging it, right? So out here, our issue in a lot of other states who have not issued orders like that, you have the situation where people are in this position, right? And of course we have alienators, right? So we have parents who alienate their kids on a regular. So now, because of this pandemic, the alienation is on level 10 or level 100, right? Because it's the perfect opportunity to say, oh, you know what? Little Johnny has a cough today, so I'm going to have to quarantine him for 2 weeks. Or, you know, I think that you might not take this quarantine serious enough, so I'm going to take the lead and say I'm the better parent, and I'm just going to not allow you to have the kids. So Jolena, what have you been having to tell your clients and people who come to you and say, hey, what am I supposed to do? Let's start with the parent who is being withheld from the kids, right? The other parent is not allowing them to have their time with their child. How are you dealing with those types of situations?
So for pending cases that are actually going on, I'll reach out to the other attorney and be like, look, you need to talk to your client. You know, they're violating the order. When we're able to file again, we're going to go back to court, and this is going to be a problem for your client. For cases where I can't do that, I mean, one thing we can do is have them contact their local police precinct, the non-emergency number, and let them know that I have an order. This person is not following the order. And so if they have the availability, they will actually call the other parent and let them know that, you know, you have to. So sometimes that will scare people into cooperating. But really, like, we cannot file anything. Right. And just this doesn't constitute enough of an emergency that a judge will actually hear the case right now. So it's kind of just a matter of, we just have to keep track of everything. And when we're able to file, you know, that's when we can handle it. And in New York, you know, if you're alienating the child to that extent and we can prove this, there can be a change of custody. So
right. So you want
I'm telling my clients, like, just be patient. You know, if they're just blatantly doing this and, you know, keeping the kids without any reason, when we're able to get back in court, then we might be able to get a change in custody.
So there's no electronic filing in New York?
Not unless it's an emergency. They are not allowing new filings right now.
So normally you don't electronically file?
Normally, we can electronically file in some counties. It's a mess in New York. We're like, especially for the matrimonial cases, we are definitely behind. So some counties are allowing it for MAT cases and some counties are not. But right now, I mean, you can't file anything that's not essential at the moment.
Wow.
Right. So here's the thing, like, right, because we have this situation where a lot of parents are just trying to figure out what to do. So I try to offer, you know, some tips for you specifically, because I know most of my cases are high conflict cases. Like my client and the other parent typically do not communicate at all. If they do, it's a hot mess. And, right. So we're using Talking Parents. We're using Our Family Wizard, all good resources for those of you who are tuning in. If you aren't already familiar, is definitely something to look into having added to your order so that all of your communication with the other parent can be in one place and the courts can look at it. That's the long story short. But anywho, it's really important that, so when you know that you're in a high conflict situation, there are some things that you have to do or should do or keep in mind to make sure that when you go back to court, right? Because for some of us, it's inevitable. You're just going to end up there, whether it's an emergency hearing during the pandemic and a hearing right after the pandemic. At some point, you'll get there. In some states, the cases are being withheld. Continued far out, right? So I've had some cases on calendar that were set for March and April. They've been continued to July and August already. So for parents who are dealing with, okay, I already know this is going to end up in court, the child is being withheld, what are some tips that we can share with, you know, everyone who's going with this situation. So I'll go ahead and start and say one thing that I always say is, obviously, if you can communicate, right, attempt to. In writing is always good, but try to communicate and figure out exactly what kind of schedule will work, what kind of plan you can put in place. Make sure you guys are on the same page when it comes to the pandemic, the quarantine, and okay, this is our agreement. We're not allowing any outside family members coming to the house. We're not allowing, you know, play dates, things of that nature. But also documentation. So can either of you speak to that a little bit and just tell people how they can document their efforts to try to cooperate, but at the same time also be able to show that whatever decision they're making is, you know, in the best interest of their child.
Right. The Talking Parents app, for those who have it in their order, and even for those who don't, you can use the app. You can download it. It's free. You don't have to have a court order or a case number to use it. So it's definitely important that you document. And I always explain to my clients, your effort to communicate may fall on deaf ears. She may not respond. She may just ignore, or he may just ignore your message. But you need to be able to show, even if it's by text, that you sent the message, that you said, hey, it's Friday. This is my regular day. And I plan on picking up the child. And then if you get no response, we can see that. If you get a horrible response, we can see that too. And those are the things that you use to document. I've had clients ask, she won't let me pick up the child. It's my day. I'm at the school. She's not here. I'm at the meeting place. She's not here. And you know, there's no relief that's immediate. That's not an emergency. We have a rule here. It's in our statute, actually, that says visitation, time sharing is not an emergency. So don't ask. So you may not have any time sharing between now and August or whenever the courts reopen, but we just have to count up those number of nights. Still try to reach out. You don't have to talk to the child doesn't have to be in your home for you to still maintain that relationship. FaceTime them, call them, do whatever you can just to keep the lines of communication open. Ask them how they're feeling, but you absolutely have to continue to make the effort. Because if you're not making the effort, the logical defense on the other side is going to be, oh, he didn't try. He never called me. I didn't know he still wanted to do this. So my recommendation to my clients is continue to make the effort.
Good. Jolena?
Yeah, mine is pretty much the same. Definitely document everything, document all of your attempts. Make sure that you're texting and you're emailing and you're keeping track of the days that you're supposed to have that you don't have. And, you know, just keep, like Deborah said, keep communicating, keep making the effort so that you have all the evidence you need when you can go back to court and you can file. You can show all the efforts that you've made to see your child.
Right. And another thing is just here's the reality when it comes to co-parenting and withholding your children. And this is what I've been sharing with a lot of people. I've talked about this topic probably a million times in the last few weeks. One thing that you have to understand, specifically if you're the parent who has custody of the child and is not allowing the child to go with the other parent, if you already have a history and a track record of, you know, the other parent has been complaining about you withholding the child or not letting you speak to the child and not letting you visit, you know, not letting them visit the child and things of that nature, you essentially could be putting yourself in a bad position to where whenever you get back into court, right? Mm-hmm. If you are withholding your children without justifiable reason, and I don't think he's going to wear a mask when they go to the grocery store is potentially a good reason, but who knows? And that's the thing that a lot of us are going to have to deal with, because this is such an unknown area, with the exception of Florida, right? As of right now that we know about, that has all of these rules in place. The rest of us are out here winging it. Like, okay, we don't know what these judges are going to do. We don't know how they're going to respond. We don't know if they're going to start switching custody, if they're going to grant makeup time. So you have to keep all of that in mind, because you don't want to make a decision that you're claiming is in the best interest of your child. And it may or may not be, but you don't want to make that decision and then find yourself in a position where you're losing custody, because we have that same statute in California. You know, the parent who is going to facilitate the child's relationship with the other parent is the one that the courts deem to be the parent who should have custody of the kids. So this pandemic is the perfect opportunity for you to show that you're that parent, that yes, there's a pandemic happening, and I still made sure I did all of this communication. I still, sent emails and voicemails and text messages and photos and tried to do Skype and FaceTime or whatever it is to make sure that my child still could have that relationship with their other parent. I wasn't trying to withhold them. I was legitimately concerned for their safety, but I was putting other measures in place.
Right.
So what about situations where we have, because this is a pandemic, right? It's a health crisis and it's everywhere. And most states, cities have something in place, stay at home, different. I know every state has their own orders in place. So there are some situations where alternating custody, right, is just not going to be reasonable. It's not going to be practical, specifically, obviously, in situations where the parents are co-parenting out of state or out of county and it's far and they're not allowed to travel. How do we suggest that, parents who are dealing with that navigate that piece? It's not reasonable, even if the other parent is insisting. Obviously, we're not going to tell you to violate your orders. Like, that's just not what we're going to do. But, what are you sharing with people when they ask that question? And I know you guys, we have some questions in the comments. I'm going to click through those and make sure that we get to those. I'm just trying to get over the basic questions that we already have and have been getting over and over and over before we dive into that.
Right.
So, yeah, go ahead, Deborah.
It's a health crisis. And so no one is asking you to put your child in harm's way. And none of the judges are going to order you to put your child on the airplane if the airlines are having issues, or if there's an order in place that says that you shouldn't be traveling into another state or outside of another state. So the judges are using common sense, and that common sense may not translate well in your household, but this is the first time that we're dealing with many of these issues. So you have to dig deep, and you have to use your own common sense. You have to apply your common sense to what works for your family. You absolutely have to have a conversation with the other side. Nothing replaces a conversation with the other side. And that's probably the hardest thing for most of my clients to do, is to suck it up, right? And pick up the phone and just have a conversation. Like, I know I live in New York. I know you live in LA, and I know I'm supposed to have the child for the summer. And so are you sending the child to me for the summer? You just have to have that conversation. And so, pettiness aside, it just has to be that way. Because if you don't do that, what you're doing is you're really putting your baby in the blanket, no matter how old or big the child is, and you're leaving him at the courthouse stairs. And you're saying to the judges there, I don't know what to do. We don't know what to do with this child. We can't figure out how to get our child's life together. So you do it for us. So that's not a good place to be. So you just have to use your common sense. You can't, if you guys live a mile away from each other, you have to do your time sharing that way. If you live out of county, you have to have conversations about the travel and who's working and where you work and how you get around, and you just have to make it work. But the biggest challenge in this entire pandemic is not COVID. It's our parents. They're fighting, and the disease and the virus is not, it pales in comparison to the bad behavior of some of these parents, right? So if you couldn't have a conversation before with your co-parent, you're certainly not going to have one now, right? But this is the time that your child needs it the most. And I think we just lose sight of it. We just forget about the child, and we just take advantage, like, oh, yes, she works in the hospital. She's an ER nurse. So I know she's exposed on more often than I am, because I work out of my house. So the child can't go over there. And they just prey on the fact that this is an opportunity to behave badly. So if you could get out of that for a second and, co-parent, it's a health crisis. Be professional parents. Treat your co-parent like you would treat your boss. Have this conversation. It's so important for your children, because we don't have the answers. We can sit here and talk all day to you and say, this is how to do it, and this is what the judge is going to do. They've given us some direction, but still some of it is left up to interpretation. So we don't know. We hope. We'll make our best arguments, and then the judge is going to decide, was this unreasonable? Did you withhold? Why couldn't you let them FaceTime? All these types of questions come up, and they're just going to wing it, right? So if you want a judge winging it and raising your child with you, then great. But if not, figure it out together and make smart decisions that work for your family and keep the health of everyone involved, especially your kids, especially the siblings. We don't think about the fact that they're used to going over there every other weekend and hanging out with their brother, but now they can't if you don't allow it and you don't have a valid reason. So it's really us behaving better as parents.
And to add to that, it's really important, like Deborah has mentioned before, it's really important that you use your common sense and that you do what's best for your child, right? Like there are some situations where it makes sense for the child to stay with the other parent. And that's just the reality. Of course, you're going to miss them. Of course, you're going to want to see them and spend time with them and hug them. But I'm sure that you would rather them be safe than risk coming back and forth. We just saw one case where a parent lost custody. I'm not sure if it's a temporary order or a permanent order, but one parent, I believe it was in Florida, Deborah. I'm not sure if it was, but she lost custody because she's an ER doctor or surgeon, and she's exposed every day. And the other parent filed a request and was able to secure custody. I don't know if that's an unreasonable order given the circumstances, right? Of course, we don't want to take custody away from someone who's doing their job and trying to save lives, but at the same time, we don't want to put our kids at risk either, right? So, Jolena, what are your thoughts on, how people can navigate those situations and make that decision that makes the most sense when it comes to, okay, do I need to just say, okay, child, you're going to have to go with dad today because...
So I'm telling my clients, like you just said, what's the best interest of your child? Putting away your feelings for the other parent, putting away, your desire to spend as much time with your child as you want to. What's really the best thing for them? Is it the best thing for them to fly, to visit you in another country, even though it's your parenting time? Is it a good idea for them to, go across state lines right now? Even, in New York, is it a good idea for them to have to get to you on the subway? Like, is that what's best for your child right now? Or can you talk to the other parent and make other arrangements where you can make up the time at a later date, or when it's more appropriate, something that's better? Like, it's different if you can drive between houses, but it gets really tricky in New York with the public transportation and everything. And I've had to have conversations with my clients about, is this do you want to have your child on the train going back and forth every weekend, or can we work out something else? So really just talking to people and being reasonable. If you have a job, an essential job where you have to go out every single day and be out in the public, do you think it's best for your children to live with you right now? Or the other parent is sitting working at home and they don't have to go out right now. You really have to think about, what's going to be better for them. Like, how would you feel if they got sick because you made these decisions just because you didn't want to have the time away from them? So again, it's something that I can't tell people to violate the orders. I can't tell people that they, don't see your child if they feel like that's something that they want to do. But you really have to think about it and think about the fact that, look, later on, this other parent is going to take you back to court to modify the agreement. What do you want the judge to hear? Do you want the judge to hear that, she made me take the kid on the subway, every weekend? Or do you want the judge to hear that, we worked out, an agreement where I'd get more time down the line. I got to FaceTime the child every day. Or maybe we worked out an agreement where I couldn't see them as often, but we were able to, drive or Uber to see less often, but in a safer manner. So really just telling them to look at what's best for the child and not what they want, or to get back at the other parent, or, to make sure that the other parent is not getting something that they don't think the other parent should have. So right now we got to put our needs aside and focus on what the child needs and what is in the best interest of the children. And it's a long game. You can't just look at what's happening right now. You got to look at what's going to happen in the future, because I'm telling you right now, there's going to be a lot of changes in custody coming up in New York for sure.
Wow.
Yeah,
Right.
absolutely. And that's so good, because that's the same way I've been having to, and I've been having to have some hard conversations with my clients, right? Like it's hard to hear, maybe you need to just let their mom keep them.
Right.
Like you want to, especially when your time is already limited and you're only getting every other weekend, or you're looking forward to this spring break that you just missed now, and summertime is coming up, and we don't know what's going to happen, right? So that's one reason why it's so important for everybody to step it up. And I know you hate the other parent, or you may in this particular moment, but all of that aside, we're talking about life or death here when it comes to your kids, right? So they come first. What's best for them comes first. So let me dive into some of these comments, because we do have a lot of them. Now, before I even start reading, I know that y'all be wilding out my YouTube comments. So if you got some foolishness in the comments, I'm gonna skip right over you, and I might just block you. So don't start with me.
I might want to hear it.
You go to my channel and you just scroll through, you'll be like, oh, really? I'm a black word every other day. Okay, so let me go through question number 1. Actually, let me turn off this thing real quick. Okay. Question number 1, does the custodial parent have to give missed time back to the non-custodial parent due to missed visits during the quarantine?
Me. Yes, and yes. And why wouldn't you want to, really? Our administrative order says that time sharing will be considered, makeup time sharing will be considered, and I can't think of any scenario why a parent wouldn't want to do that. And it doesn't have to be, oh, I missed 3 months, so now the child is with you for 3 months so that you don't see your child for 3 months. It can be staggered. It can be an hour or 2 a day here until we total up the number of hours missed. So it will be a balancing act. And it's only fair, because you don't know what issues your child had in not having the time sharing. So it's not just about you as the parent. The child may have been fearful that you weren't coming back, the other parent. The child may have missed the relationship that they began or fostered with their siblings. And so the child still has feelings. So we want to try to massage that back to regular and massage it back to normal for everyone. So it's not just, I missed the time, the child missed the time too. So yes, here in South Florida, makeup time sharing will happen. It'll be something that you can be creative with. If you miss 3 months, which I really hope no one misses 3 months with their child, but it'll be a night here, 2 nights here, spring break here, until we total up the number of overnights that was missed. So that's a yes. That's a yes.
And I think that might apply whether you have an order in your state in place or not, as far as, what should be happening, right? Like, it's just, if you're going to keep the child, you're the one that's protecting the child, making sure that they're safe every day, and you're going to keep them for the duration of this pandemic. Again, it goes back to, how are you going to show that you're the parent that is going to facilitate custody? And this just wasn't a tactical move for you to alienate your child. So there should be no reason, minus, of course, safety reasons, real safety reasons, not I got an attitude, so I'm going to act like there's a safety reason.
Right.
But, even if there's no order for makeup time, you should at least try to facilitate that. All right. So I'm going to go to the next question, which is, if the custodial parent made the decision on her own to keep the kids home and the sitters during this time, is the non-custodial parent able to have other options to visit or see the children? Jolena, what are your thoughts on that?
So, I mean, if the custodial parent is keeping the child and has sitters coming over to watch the kids, I don't see why the non-custodial parent couldn't see the kids during that time if she's having people in the house anyway. So,
right. And it's really going to go back to communication, right?
Yeah.
Now, if if the sitter is coming in and out and is watching the kids, and she won't allow you to come over and visit the kid, that's what he or she, I'm not sure who this is from.
Right.
But the other parent won't allow you to come, even if it's just to come and, you know, sit in the front yard with the kids and play for a little while. You might have a strong argument that this wasn't about our child's safety. This was about control. Right. So we got to look at the facts of every single case, right? Every single circumstance is going to be different. Every judge is going to be different, which is why we're trying to keep y'all out of the courtroom, because this is going to be a mess by the time, you know, you do get back into court. So,
but you know, in that, I'm sorry, in that situation also, if there's an order already in place and mom or whoever just decided, you know, I know best, and the child is not going, that may be a situation where the non-emergency law enforcement could assist you with that, because you already have an order. So at that point, it's like, it's Friday, it's 9 o'clock, I'm supposed to have the kids and I don't. You may be able to get assistance in the moment for a resolution there, as opposed to waiting and documenting that until you get back into court.
Right. And I know, like, out here in California, our police officers, they ain't enforcing nothing right now. Everybody is in the house. They're like, yeah, okay, you calling because you just going, this is a civil matter, take it back to court. Like, they're not even, but I do know that some other states and some other cities are, you know. So you're going to have to check with your local law enforcement to see what their policy is right now, given the circumstances.
And maybe just document it, and maybe just get a report. They may not go out to the other house, but you'll at least have a report to document it.
Right. So the next question is probably for you, Jolena. My daughter lives in New York City, and the city messed up my visitation order when there was a change of guardianship. They refused to let me see her on my terms or let me speak to her. What can I do? When you don't agree with an order, what do you do?
Well, if you don't agree with it, you have to try to go back to court to modify it if you think there was a mistake made or something. As of right now, you can't do anything in New York City. You can't file anything. You can't modify anything. So you have to adhere to whatever the order says at the moment. But in the meantime, I would just document your attempts to see your daughter. You know, track every time you call, try to get FaceTimes, text message, email, to say that you want to see her, say you want to talk to her, and just keep track of all of that so that when you can go back to court, you have all of this evidence of you trying to communicate with your child and being blocked from that. But at the moment, there's really not a lot you can do since you can't get into the courts, and you just have to adhere to the order as it is right now.
Mm-hmm. And y'all, I am the documentation queen, right? Like, I document everything. And most of you know that I'm in a blended family, and we had a whole custody battle and back and forth, you know, years ago. And it would we could literally be like, okay, have a nice day at the end of our phone call. Phone call ended at so-and-so time, lasted for X amount of minutes. Like, you literally can go overboard. And I will, in our in the collective conversation vault, I will make sure that I put our co-parenting journal in there, just so that you can have that as a resource for you to track everything. It's got prompts in there for you to jot down, you know, phone calls, missed visits, all of that stuff, so you can have everything in one place and know how to compile that stuff to use later. Because the reality is, some of you are going to be in a situation where your child's going to be withheld, and there's not going to be anything you can do until you go back to court. So I have to tell people, and again, that's a difficult conversation, right? For me as the attorney, I'm over here saying the only thing you can do is document. Because that's all you can do, right? As the parent, you hear that, and it's like, dang, I got to go all of this time without seeing my kid. Like, how can, but I mean, again, world pandemic, and they are focused on other stuff right now. So the next question is, please address whether a custodial parent can deny remote parenting time by way of video conference call. Can they?
Short answer.
Should they? They should not.
They shouldn't. That's the easiest thing to do right now.
Right.
I mean, why would you not do that? Right. So yes, the short answer is yes, they can. But the long answer is they will suffer consequences for having done that. I mean, because the world has shifted to that now. So not only have you, we're in court, so you've there's been an issue with the regular time sharing, but now the remote time sharing is a problem. Also, in our order here, the judge specifically talks about video conferencing and phone contact should be honored at a minimum, but it should also be increased to regular and consistent contact, because they recognize that, again, the kids, depending on their age and maybe not depending on their age, they're scared too. Right. So they're used to seeing you every couple of days, and now they don't see you at all. They may develop some anxiety regarding that, feeling like you're gone, you're not coming back. So right. Yes, parents can do it. Should they do it? Absolutely not.
Right. Okay.
This is the time to be creative with that kind of stuff, you know?
Let's see. Sorry, we got a whole lot of comments, so I'm trying to get.
While you're looking through that, I had a call this week from a client who is struggling with accepting the child more often than he is supposed to due to the co-parent's work schedule. She's an essential ER nurse, and so she's been working more than she should. And so now she's leaning on him a little heavier. And so we had to have a conversation about that. Like, he doesn't believe she's working, and, you know, he needs her schedule approved. And so, you know, we gotta do better, people. You know, I don't think this is something that she plans, and she probably doesn't enjoy, but who else would she want? You want her to send the child to if she has to work? You know, if it was the other way around and she was getting a sitter, as someone else said, you'd have a problem with that. So, you know, you're going to have to step up. She's stepping up, so you have to step up. So it kind of works both ways here.
Right. So I see a comment that says it's referring to how many men have taken their life because they don't get to see their child. So I just want to address that, because I am a father's rights attorney and I represent some amazing moms, but I primarily represent fathers who have difficulty, you know, establishing or maintaining their relationship with their kids. So one thing that I want to make sure that I say, just because I saw this comment, is your mental health right now is extremely important for you and your children, right? So at the end of all of this, a lot of kids are going to need, first of all, children in divided and family, blended families already need therapy off top, usually if their parents are high conflict, right? Because you guys be acting a fool and send your kids into this cycle of tug of war and feeling like they have to please mommy, please daddy, do this, do that. So your kids are going to need mental health, potentially need mental health services, you know, on their own. But in addition, you got to make sure that you maintain your own mental health as well. So if you do not have a mental health therapist and you are, you know, struggling with alienation and things of that nature, I definitely want you guys to seek that. And we have some resources that we can share, just so you can tackle that, so that when it's time to move forward in your custody case, that piece will be handled. Okay.
Yeah, absolutely.
Let's see.
It's definitely a process that requires a lot of patience.
Mm-hmm.
And
can the judge deny an emergency hearing motion filed by the non-custodial parent that contests the temporary denial of parenting time? Oh, by the way of remote technology. I think we kind of answered that question already. In most states, denial of parenting time is not considered an emergency, unfortunately.
Right.
So in those situations, you have to deal with, you know, waiting it out until your actual hearing date. I know that's our experience here in California. Just because your children, I've had clients who didn't see their kids for a year, and by the time they came to me, we file a motion and we don't get in court for another 3 months. And there's literally nothing that they can do because the court doesn't consider it an emergency. Now, we were able to flip things around, but from that moment, you know, I don't think courts are issuing emergency orders specifically for that type of stuff, especially not right now. Okay. Let's see here. What if when a non-custodial parent? Okay, I'm gonna let someone speak to this while I go grab my charger.
What if
before the line cuts off?
All
right, what if a non-custodial parent? Y'all can read the question.
Yeah. I just had a conversation about this, so if you want, I'll take it.
Go ahead.
Okay, so the non-custodial parent is ordered to have communication with the child, and I think that's what your question is asking. You're ordered to have FaceTime with the child every day at a certain time. Some orders even go as far as saying that conversation should not be interfered with, and the child shouldn't be coached in the conversation. If the conversation is taking place FaceTime and the child is sitting there with the phone and you can see or you can hear the other parent in the screen as you're having the call, then just a quick note to the other parent, hey, can such and such go to the other room while we talk for a few minutes? If you can say that in a respectful way, I would start with that, especially if they're in the conversation with negative comments, because you're not having a conversation then with your child, you're really having a battle with your co-parent. So if you can find a way, you can dig deep and just say, hey, Sally, can Brandon go into the other room and talk to me for a few minutes? See where that goes. If it goes nowhere, or if you get more negative comments, then you're going to have to make your conversation short and focused. Make your comments directly to the child. I don't know if the negative comments that you're referring to are directed at you, or if she's just screaming in the back, or if she's telling the child to say things back to you, but try to keep it focused. How was your day? I don't know how she could answer that in a negative way, but try to keep your conversation focused with direct questions, and listen to the answers, respond to those answers, and make it a quick call. So make it focused and make it quick for that call. You then have to correct that situation. So if it's in your order, then you have to reach out to your attorney to get guidance on how to correct it, especially if that person is represented by counsel. That should be a quick call between both lawyers. But you can't stop someone's actual behavior. Although we would like to, we can't make someone do something or not make them do something. So you're going to have to find an alternate way in your conversations with the child that have to be adjusted in your order. So you have to deal with it in the moment, make your call quick and focused, but then you're going to have to adjust it so that you're not subject to that every time you're supposed to have a call with your child. You have the other co-parent screaming obscenities or making comments or telling the child to respond to you in a certain way. It can be fixed. It can't be fixed in the moment. It doesn't mean go into a shout match back with them while the child is on FaceTime talking to you and now the two of you are arguing. But in the moment, adjust to focus and quick, get off the call, and then we can deal with that at another time.
Awesome. Okay. Let's see here. I got a few more questions. Let's see. What if they refuse visitation? Most of these questions have already been answered. Okay. So, are there any more questions that we have not covered yet? Let me see in the chat. I don't see any more. Let's see. Is there anyone else that has any questions? Let's see. Okay, do any of us foresee the judgments being made like this one? I think they're referring to the parent who lost custody being turned into a final judgment. What are your thoughts on that?
The doctor that temporarily lost custody, I don't
Right.
see that being turned into a final judgment. I think that's just the solution to the problem right now. I think that once this is no longer an issue, that wouldn't be turned into a final judgment.
Absolutely not. And I think the judge even suggested that in his order that this was a extreme situation, not intended to in any way be permanent. But in his opinion, based on the limited information he had, he felt that that would be in the best interest of the child.
Right. I see a question related to child support, and they are asking if the makeup time isn't granted, will that be factored into child support?
I can tell you in New York, no, it's two separate things. Child support has nothing to do with the time you spend with your children. It's a completely separate issue in New York. So that wouldn't modify child support in any way at all.
Right. Same here in California, essentially. Child support and custody are two different things. Now, when it comes into the timeshare, it could, if it were a substantial amount of time that was missed, right? Like if you're missing 6 months out of the year, then obviously that timeshare is going to be less than it normally would have been. But then we have to factor in, obviously, again, this is a pandemic.
Right.
So I don't anticipate the court saying, okay, you missed more time with the kids, so now you have to pay more support because you had the kids less, right? Okay.
I'm wondering if what they're asking is for that period of time, should they still have to pay? And the answer is probably the same. You still have to pay the same amount. But for example, if I filed a petition to modify support and my order says that I have half the time with the child, so I only pay $20 a month, but she keeps the child from me so that I don't have half the time, will she be entitled to more money for those months that she had more time? I wonder if that's what they're thinking.
I think my answer would still be the same. I think given the pandemic and everything, I don't see that the judges like modifying child support either way, more or less in this situation.
Right.
I see a question from Destiny in the comments. It says, if the children threaten to run away during this time, is this a reason for emergency custody?
In Florida, no. I would say,
I'm going to say in New York, no.
And a threat to run away and actually running away are probably two different things, right? And I think that the age of the child is definitely going to have some play into that and how that will turn out, the reason for the running away, all of that stuff. I would anticipate if a child is running away, they would order some type of therapy for the child, or if there is some alienation or something like that going on, and that's why they want to run away. I don't know if it would be grounds for an emergency order. Probably not. When we talk about emergency orders, specifically in California, we're talking about domestic violence, international kidnapping, real kidnapping, y'all, not
life and death
for 2 days extra. That's not an emergency.
No.
Things like that. Your child has to legitimately be in danger.
Right.
It's the same for New York. It has to be that level. They're not going to even just keeping the child away. That's not enough. It's got to be physical danger.
Right. For us here in Florida, the child emergency has to be imminent and impending. It has to be abusive and neglectful, abandonment. It has to pretty much be life or death for it to be considered an emergency.
Okay, let's see. We have a couple more. I'll take a couple more questions. What can be done if the custodial parent always has phone issues and refuses to use talking parent? Would the judge more likely put it in the order I'm assuming you're referring to putting the talking parents order into the order if you don't already have that into your order. I have not had a judge deny me a request to require the parents to communicate by talking parents, or even for phone or video time, unless there was like domestic violence or something like that. What have your ladies' experience been with that as well?
Oh, I very often have it put in orders that you have to be specific. I find that it's easier. This is the time you're going to call the kid. If it can't happen through, whatever talking parent or whatever other app, it's got to be video, it's got to be phone. I prefer to have a set time, and then the parents can agree on a different time if they need to, so that, you can always guarantee that it's going to happen. And I've had to go back to court where the phone calls, it didn't happen. And again, in New York, so a lot of my judges are like, look, if you are alienating the child, you can lose custody for this. So you better make sure, no matter what you have to do, you got to make sure these phone calls happen. However you have to call the other parent, you got to make it happen. So I think that it's actually better to have it in the agreement, especially if you're dealing with a person who historically is going to play these games and act like the phone doesn't work, or they can't get the app to work, or it can't happen. So just get it in writing, get it in the order, and just keep track of all the times. Like I have my clients get a calendar and just write it down. The phone call was supposed to happen at this time, it didn't happen. So we can go back to court and we can say, look, these are all the calls that were missed. This is all the technical issues they had. We have all the dates and all the times, and that's when you can get things to happen instead of vaguely going in and saying that, oh, she always has problems. But if you do the documenting, like we keep saying, document everything, you can make things happen.
Right. I agree. Same here. We go back to documenting. It's like it's a business. Co-parenting is a business, so you have to document it. And I usually have the same receptiveness from the judges. When you ask for talking parents, there's a free version. There's a version that you pay for. I have to be very specific that it's a certain time. If you put a message in, you have to review your messages every day. You have to set up an alert, because that's the next thing. Oh, I didn't check it. And then you have to respond. You can read it all day and not do anything with it, but you have to check it. You have to be alerted, and then you have to respond within a certain amount of time to any messages that are left in there. And so if they're having an issue with the quote unquote phone, the app is always an option, because there's not very much that you guys need to talk about over the phone, you and the co-parent. If you're doing what you're supposed to be doing in the order, it's not much to talk about outside of that. But sometimes you want to share information and you want to get answers. The app is the best way to go.
Okay, we're going to do 2 more questions before we head on out. So the next question was related to changing a judge. Is there a way to petition the court to change your judge? And if so, is that petition that you file going to be heard by that judge that you're asking to change?
Yes.
So I guess I can start. In California, you can challenge a judge as soon as the judge is assigned to your case, right? You can challenge it without question. There's a code section that allows you to change the judge. So if there's a judge that I know I just don't like to appear in front of, or that my cases just go all the way left with, then I'll challenge it when the case is first open, right? But once you've had a judge already on your case, they've been hearing your case, unless you can show some kind of bias or prejudice or abuse of something, typically they're going to be like, nah, you got to stay where you are. How about, and I believe that pretty much is the process across the board, but you guys chime in on your experience.
So in New York, we can't just change judges like that. Just because you don't like the judge, you can't change it. You get who you get, unless there's a valid reason, unless there's a bias or there's some sort of conflict or something. In family court, if you get assigned a referee, you can say that I don't want a referee, I want a judge instead. But again, you won't get to choose, who it is. You can get it transferred from a referee to an actual judge, but we don't have a lot of, you're kind of just stuck with who you got for the most part in New York.
The same in South Florida. It's the same. Your case is randomly assigned when it's filed, and you get who you get. You can ask a judge to recuse him or herself, and they are the one that hears the motion to recuse. So you make that argument, and if you don't win the argument, you're stuck with that judge knowing that you wanted him recused, And so sometimes that doesn't go so well. Some judges and attorneys have a standing order of recusal, like they used to be partners in private practice, or they were married to each other, or some other way. There's a standing order so that any case that is filed that's randomly assigned to that particular judge automatically has to be reassigned for that reason. But for the most part, you're stuck with who you get. And, if we allowed you to change judges every time you got a bad ruling, which is usually when you want a new judge, we'd never get any work done. So you're stuck with who you have. You just have to know who your judges, know who you're in front of, prepare yourself, your clients, to represent and put on your case in front of that particular judge, knowing their history and their background.
Right. So the last question is, I'm gonna just combine two questions. Someone is asking about how you can prove alienation during this time, and then someone is asking what exactly is documentation. So proving alienation, that's a whole nother video in and of itself, right? Because alienation has so many different layers to it, right? You can have physical alienation, emotionally alienation. You can have the coaching where parents are, brainwashing their kids to say things about you that are not true, but the other parent believes or wants your child to believe. So there are so many different layers of alienation. But if we're talking about physical alienation, again, it comes back to the documentation. So what I like to tell people is, whenever you're making a request to the other parent, I want to see the child, I want to visit the child, I want to take the child here, I want to talk to the child, request it in writing. Too many times we pick up the phone and say, hey, I want to see them. And they're like, nah. And then we're like, well, I called. You need to be able to show. And I see that someone responded to the question in the comment and said, send text and try phone calls. No response is a response. Do it every day and build your case. That was a comment by Nappy Baker. And it's so true, right? Yeah. Like I'm telling you, when we were going through our custody battle, overboard. I'd rather you have more documentation than you need than not enough, right? What are your ladies' thoughts on proving alienation and documenting?
I'd say that exactly what you said. Just I tell my clients, especially when we have a case going on, don't call. What do you need to call for? Email, text, all communication, make sure that's in writing. If you do have a verbal conversation, follow it up, send a text, as we discussed while exchanging the children, XYZ. So you always have that documentation of what happened, what didn't happen, any conversations that you have. So I think in keeping track of everything, if you came to pick up the kids and they didn't, they didn't answer the door or whatever, send a text like, I'm sitting outside of the door. It's 7 p.m. The kids are supposed to come out. It's my day. So you have that evidence. And, I've used that in court, and, it was overwhelming. I could have the judge every day, every visit that was missed, every day I had my clients send them a message. They showed up every day. And it's really convincing evidence of alienation when you have that you tried and tried and tried. And like she said, no response is a response. If you can prove that you actually sent the message and they just didn't respond, they received it. Yeah. So that's the best thing to do.
Mm-hmm. I remember I had a case once. It was like one of my first cases I tried years ago. And it was a father who was being alienated. He would call and call and call and write and write. And we had literally like over 120 exhibits, right, to show his efforts. And at some point, I think the judge got tired of reading, right? Like at some point, how many times do I got to read? Can I see my kid? No. Can I see my kid? No. Can I see my kid? Maybe when you do X, Y, and Z, maybe when you pay your child support, like they don't want to see all of that over and over and over. So that's why we're saying it's better to go overboard. And I mean, don't be a stalker, right? But I mean, once a day is reasonable when we're talking about your kids. And just make sure you document and just save it all and compile it all. So I am
really quick on that. The documentation that you create for yourself is amazing, but sometimes you have to get documents from other places like law enforcement. You might just need a police report. They don't have to go out to the house and pick anybody up, but just I'm parked in front of the school, call the officer while you're sitting there, have them just write up a report that says you were there at 5 o'clock It's your day and no one else is here. And you can create a document paper trail for yourself that way as well. You have to become professional parents,
Yes.
especially when you're dealing with someone who doesn't like you anymore, doesn't love you anymore, and has an axe to grind. You have to be a professional parent, and you have to conduct yourself that way. You don't have to engage in every fight. If she's arguing and writing you messages and saying things and doing this in the presence of the child, which is one of the worst forms of alienation, you have to be a professional parent and you have to conduct yourself that way so that when you get to the finish line, because you will get there, when you get to the finish line and it's all said and done, your child still has respect for you because you conducted yourself professionally, and you can build the relationship and repair the relationship with your child. If we shift a focus to the child, would you want your child to read this message? Would you want your child to see you, running up and down the street, carrying on, arguing with the other co-parent? So if we focus on that, I think that you'll make it through this alienation period. It will be hard. It will require therapy for everybody. Your lawyer too. But at the end of the day, we'll get there and it'll all be right. And if you get your court orders early, then there's not a whole lot of talking to do. You don't have to communicate with each other that much. Get your court orders early, get a temporary schedule so you don't have to call. Can I see her? Can I come? Can I call? You already have it on paper. So protect yourself that way as well.
And just a quick tip when it comes to proving that you're showing up and the other parent isn't showing up. If you are exchanging at a public place, right? Because some people exchange at police stations. So obviously, if you're at the police station, you can go inside and document. If you're not doing an exchange at the other parent's house or the school, if you're exchanging at a Starbucks or a Target, or McDonald's or whatever, I always tell my clients, when you show up, go inside and buy a coffee or a snack and keep your receipts to show that you showed up. And that way you can keep your stack of receipts to show this is the exchange location. I have my receipt that show that I was here every single time. And I also have my messages, my text, my talking parents message, my email, however you're communicating, where I said to the other parent, hey, I'm here. Where's my child? And I got no response, or I'm not showing up. Right. So I hope that this conversation was helpful for you all. Thank you all for tuning in and for all of your questions and engaging. Thank you, Jolena and Deborah, for taking this time out of your day. Again, we are the ladies, 3 of the ladies, there are 14 of us, from the Collective Legal and Crisis Management Firm, a full service firm. We take all kinds of cases. We are in several states. We do handle child custody and family law as well, which is why we're doing this topic. And we have a lot of different conversations coming up. We've done some in the past. If you would like access to our conversation vault so you can get the replay and the resources that we reference during our conversations, you can visit bit.ly, that's bit.ly // the collective vault, all lowercase. So bit.ly / the collective vault. You can also follow us on Instagram. We are at the Collective Legal. We are also on Facebook. We just started our YouTube channel. I know some of you are streaming to my personal, or watching this on my personal YouTube channel. So thank you all for tuning in. And we hope that you found this information helpful. Please share this video. If you found any useful information, please share it so that your friends can watch the replay. And we thank you all for tuning in. And we have a collective conversation tomorrow. We're shifting gears. We're not talking custody tomorrow. We are talking mistakes to avoid in business. So if you're an entrepreneur or if you're thinking about becoming one, you definitely want to tune in. It's tomorrow, same time, 2 p.m. We're streaming on Facebook Live. So make sure that you check in for that. And we will see you guys next time.
All right.
Thanks. Bye.
Bye.